So our 1919 cases, remember, all involved cases in which the First Amendment does not apply to the states. In 1925, in the case of Gitlow versus United States, everything changes. 1925 involves a different statute, New York, the New York Criminal Anarchy Statute, also known in some states as the Criminal Syndicalism Statute. They're the same. You cannot, basically what the Sedition Act of 1918, which was eventually overturned, you cannot counsel about, speak about, protest about, organize about, conspire about, write about, have membership designed to overthrow the government of this state. And in Gitlow versus United States, New York was prosecuting a man named Samuel Gitlow, who was an avowed socialist and a bit of a literary junkie. He decided to put all of his views against the government of New York and in favor of the socialist viewpoint into a single, what he called, manifesto. It was an enormous document. How many people read it? I have no idea. How much impact it had on the government or on the society? Not much. But by writing it, he had violated the New York Criminal Anarchy Act, and so they prosecuted him. And they prosecuted him believing that they could do so because the First Amendment didn't apply to the states. Now, if I just tell you about the Gitlow case, you're missing the action. The action comes a couple of years earlier than that. The Prudential Creek Insurance Company wanted to fire some people, and there was a state law requiring that they explain to the workers why they were fired. The company did not want to explain to the workers why they were firing them. And so they sued. And it went all the way to the court. And the court decided, you don't have any First Amendment rights here. Wish you did. It's a big part of the legacy of corporate free speech and how free speech and that right grow to become Citizens United. So you've got a majority of conservatives on the court who wish they could have given the First Amendment freedom of speech rights to the Prudential Insurance Company. They would give them the power to be silent on why you're being fired. But the First Amendment doesn't apply to the states. It hasn't been incorporated in the 14th Amendment Due Process Clause. Now you have the Gitlow case. Before they can even talk about Gitlow, they have to change that rule. They have to take the First Amendment freedom of speech and apply it to the states. To do that, you would think they would make a long argument about, well, here are the rights that we understand. And what they would have done would have been to go back to the Patterson versus Colorado case in 1907. And they would have gone to John Harlan's dissent, to Oliver Wendell Holmes' view that injury to the public welfare is what the court should protect in the right of the state to protect judges in a working trial. But remember, Holmes was doing that because all he had to use was the 14th Amendment. Harlan was saying, I kind of like your rule, but I think I would use it differently. I think what I would do is say that the 14th Amendment was designed to apply all of the Bill of Rights to the states. The 14th Amendment, remember we discussed this, was designed to overturn Barron versus Baltimore in 1833. And so I would use the First Amendment. I would say that the right of the state does not extend to abridging freedom of speech. And I would say that we won't use injury to the public welfare. We will protect free speech. That's what this majority should have done. They should have said This is what the 14th Amendment due process clause was meant to do. This is what the First Amendment said. Let us now explain to you why we are reversing our previous decisions, why we are reversing what we did in the Prudential and Creek Insurance Company, and why we are now applying the Bill of Rights to the states. But in fact, this is all that they said. Justice Edward Sanford writing for the majority, for present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. In short, the First Amendment applies to the states now because we said so. That's the end of their discussion. Now they're going to apply the First Amendment to Samuel Gitlow. And here's what they're going to do. They're going to say, hey, Mr. Gitlow, you're going to go down in history as the case that applied the Bill of Rights First Amendment protection to the states. That's the good news. The bad news is you're now going to lose your trial. You're going to lose your case. Because what they do here is they basically go back to Holmes's initial opinion in the Patterson case. And they say, we are going to defer to the state legislature of New York. New York has said that being a socialist and writing as a socialist is a problem for the government. It undermines the possibility of the government continuing. It tends to risk overthrowing the government of New York. We think those words, the legislature says, have a bad tendency. This is the bad tendency test. We think that you have the power to carve out of the First Amendment any kind of expression of socialist views, or for that matter, communist views, that undermine the authority of the government, that tend to seek the overthrow of the government. And the majority of this court, Sanford says, believes that we should defer to the legislature and agree that this has a bad tendency. He argues, such utterances, by their very nature, involve a danger to the public peace and to the security of the state. They threaten breaches of the peace and ultimate revolution. And the immediate danger is nonetheless real and substantial because the effect of a given utterance cannot be accurately foreseen. We are not using clear and present danger. We are using bad tendency. The government says you can't say this. If you say it, that's it. We don't look at intent. We don't look at effect. We don't look at clear and present danger. Why? Sanford says the state cannot reasonably be required to measure the danger from every such utterance in the nice balance of a jeweler's scale. A single revolutionary spark may kindle a fire that, smoldering for a time, may burst into a sweeping and destructive conflagration. We are right back where Holmes was in Patterson, where Holmes was in Schenck, Debs, and Froelich. If you say it, we can assume that there will be an immediate forest fire consuming and destroying the government of New York. We accept the legislature's view of this. Well, Holmes and Brandeis had a field day with this one. Now they were going to use clear and present danger. Remember, this new bad tendency test is not clear and present danger. It's a carve-out of the First Amendment. If you think that this phrase has a bad tendency, then it is the same as what Chaplinsky will call conduct. It can be carved out of the First Amendment. Holmes and Brandeis are now going to continue the thread that they offered in the Abrams case, and they're going to say, just saying this isn't enough. We need to see the immediate, dangerous, imminent, bad result from the state. They need to prove what the harm is. In their words, it is said that this manifesto was more than a theory, that it was an incitement. Every idea is an incitement. It offers itself for belief, and if believed, it is acted on unless some other belief outweighs it or some failure of energy stifles the movement at its birth. The only difference between the expression of an opinion and an incitement, in the narrower sense, is the speaker's enthusiasm for the result. Eloquence may set fire to reason. In short, let the free marketplace of ideas operate and allow for the court to see whether truth will predominate or whether there is an actual danger to the government of New York. But again, only two of them, 7 members of the court, are going to invent the bad tendency test to allow the governments of different states to carve potentially harmful speech that might threaten the continuation of the democratic government of that state. They can carve it out of the First Amendment and they can punish it at will. And that leads us to the remarkable case of Whitney versus California in 1927. This is very similar to the Gitlow case. It involves a woman, Whitney, who is an heiress. She's very rich, and she is flirting with the Socialist Party. She's going to meetings. She's listening to their speakers. Just what she is doing to try to threaten the government of California is not clear. The law that she is charged with violating because she attended the Socialist Convention in California is the California Criminal Syndicalism Act, identical to the act that was in New York. You can't do anything to overthrow or threaten the existence of the government of California. All she's really charged with is going to the meeting. There is no indication of any bad harm coming from that attendance. But now that you have the bad tendency test, you don't need to look at anything that Whitney's doing. Edward Sanford writes the majority opinion and says, just as was said in the Gitlow case, there's a bad tendency here. These words have been carved out of the First Amendment, which now applies to California using the Gitlow case. And it allows for the court to say, we're just going to defer to the state legislature. We're going to allow them to put people in jail for being socialists. Holmes and Brandeis do a remarkable thing. What I'm going to be talking to you about will sound like a dissent, but it's not a dissent. It's in fact a concurring opinion. It's a concurring opinion because the lawyer for Whitney realized with the way that the court was ruling in clear and present danger cases, there was no way he was going to get 5 votes in favor of clear and present danger. Best he could get was 2 votes. So he argued his entire case against Gitlow. He argued his entire case on the bad tendency question. He argued that there was no bad tendency to what Whitney was doing. But that is a losing argument as well. The way that they had made this argument in Gitlow, all you needed to see was a law that said you could not say these things or believe these things, and you could be put in jail because that alone had a bad tendency. So either way, he's going to lose. But because he never raised clear and present danger, it allowed for Holmes and Brandeis a free essay. We have a chance to concur with our colleagues. If we were voting on the basis of bad tendency, you'd have it right, and she should go to jail. But really what we want to talk about is, what does clear and present danger mean now, after Abrams? What should you have done? And what strikes us is you are putting people in jail not for things that they do, not for bad acts that actually occur from the speech. You are putting them in jail because you are afraid. You are afraid of their views. You are afraid of socialism. You are afraid of communism. You think maybe something bad will happen and it will be the end of democracy. You don't trust the free marketplace of ideas. We do. And so Holmes and Brandeis begin in their concurring opinion, fear of serious injury cannot alone justify suppression of free speech and assembly. Men feared witches and burnt women. It is the function of speech to free men from the bondage of irrational fears. You have to see something actually happen. You can't write a law, ban a type of speech, put people in jail for that speech just because of your fear, rational or not, of what might happen. You've got to wait to see that happen. Now, having really argued in a majority of those 1919 cases that you really had to see very little, that there was an emergency, natural tendency, reasonably probable effect, the word if, the fact that somebody had a belief a month before they actually said something to the Socialist Convention. Holmes and Brandeis now wanted to explain what they meant in Abrams when they were using words like imminently and dangerous and behavior and immediately. They wanted to put them together in some phrases that would make it clear that the danger that has to result from the speech that you want to ban has to be almost contiguous, almost connected. There has to be almost no separation between them. It has to be more than clear and present. It must be imminent. And so they continue. To justify suppression of speech, there must be a reasonable ground to fear a serious evil will result if free speech is practiced. There must be reasonable ground to believe that the danger apprehended is imminent. There must be reasonable ground to believe that the evil to be prevented is a serious one. Every denunciation of existing law tends in some measure to increase the probability that there will be a violation of it. You've got to see a serious evil. You've got to see an imminent evil. You've got to see an immediate evil. It would be wonderful if there were some metaphor that could be used connected with the free marketplace of ideas to crystallize what imminence and immediacy and danger meant. And Holmes and Brandeis, two of the greatest writers on the Supreme Court, two of the greatest intellects on the Supreme Court, without question, two of the men who saw into the future and who 500 years from now, they will still be talking about the brilliance of Oliver Wendell Holmes and Louis D. Brandeis. They came up with a metaphor that crystallized what they meant, not by clear and present danger, but by imminent and immediate danger. That's what the test was becoming. Here's the new test. To courageous, self-reliant men with confidence in the power of free and fearless reasoning, applied through the processes of popular government, no danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there is opportunity for full discussion. I'm going to read that one more time. No danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there is opportunity for full discussion. In short, if the result of your dangerous speech almost immediately destroys the free marketplace of ideas, there's no opportunity for tolerance. It's immediate incitement. It's immediate triggers of action. If there is no opportunity for full discussion of that contrary view, then that's clear and present danger. We're going to shut it down. That's conduct to us. They're telling us that the carve-out that they are looking at is a very limited carve-out for national security, for protecting the government. I describe it to my students this way. Imagine that there is a speaker who says we need to overthrow the government of whatever state. Imagine that that speaker gets a small army behind them. Imagine that that speaker goes to the state capitol. Imagine that that speaker continues to speak about the need to overthrow the government of the state. Imagine that speaker pulls out a bottle that is clearly a Molotov cocktail. Imagine that he continues to speak, shaking this bottle with flammable liquid in it. Imagine that he has a match or a lighter. Imagine that he lights the lighter, but keeps it away from the bottle. I would argue that everything he's done to that point may well be protected because there is still opportunity for full discussion of these ideas. The minute that he takes that lighter and moves it toward the fuse in the Molotov cocktail, to me, now we're looking at, oh, maybe there's no opportunity for full discussion. Now we can have a long discussion about, am I waiting too long? And I probably am. If I were on the court, probably I would shut it down the minute I see the Molotov cocktail. But I can't tell you what I would do without seeing the actual facts of the case in front of me. The concept, though, is clear. The minute that my statements become action or conduct because I am threatening the free marketplace of ideas of the working government of the state, that's the end. And so when I look at Whitney, I see that maybe we are no longer in the area of balancing out rights. Everything that we have been talking about since the Patterson versus Colorado case, everything from the Masses case up through the 1919 cases to the Whitney case, it is all intermediate scrutiny. It is all balancing out the interests of the government controlling speech and the interests of the speaker to be allowed to express their views. It's at what point do you shut down the speech? And the rule goes from clear and present danger to imminent and immediate danger or no opportunity for full discussion. But when you get to the words imminent and immediate and no opportunity from discussion, you have moved your protection of that speech up higher in that intermediate scrutiny level. And it may be the case that you have now slipped over to strict scrutiny. It's something that you can debate with your classmates and with your professor. And it's one of the interesting things trying to figure out how these tests are placed on these areas that are intermediate scrutiny and strict scrutiny. What is also debatable is when you look at the Patterson case, the injury to the public welfare rule, and when you look at the Gitlow and the Whitney case, the bad tendency test, are we talking about lowest level of scrutiny? Are we talking about a rational basis test or a reasonableness test? Or have we slipped below that to a carve out? If the government says that this is a bad law, bad speech that should be regulated, we are carving that out of the First Amendment. You can debate that point as well. Just how little rights do you have when you have a bad tendency test? Just how little rights do you have to speech or press when you have Holmes's version in Patterson of the injury to the public welfare test? Well, Holmes, at the very end of his life and at the very end of his career, in 1929, gets one more case that deals with this issue of freedom of speech and freedom of thought. This is the Schwimmer case, Schwimmer versus the United States, 1929. Here, a woman who is in her late 40s, early 50s, is asking to be naturalized as an American citizen. She's a very eminent lecturer, professor, linguist. And she is denied American citizenship because the government says there is a clause in the Naturalization Act that requires that people swear allegiance to the government of the United States and be willing to fight in favor of the government of the United States. And being a professor, she's a bit of a contrarian. And she says, look at me. I'm in my late 40s. I'm not going to fight for the United States government, nor would they ask me. And I'm not sure I want to give a blanket agreement to be willing to fight for the government of the United States. I don't know what they're going to be doing. I don't know what kind of wars they're going to be fighting. So I'm going to be a conscientious objector to that provision. And the American government says, we don't have to naturalize you. We don't need to naturalize more conscientious objectors. We're not going to allow you to become an American citizen. Not surprisingly, the 7 members of the Supreme Court who have been conservative all the way through this era have no trouble in saying, well, the Naturalization Act says you have to do this. It's pretty clear. You refuse to do it. So it's not that you spoke badly and there's a bad tendency. It's that you refuse to speak in favor of fighting for the government of the United States. And it is reasonable for us to defer to the government and say the government knows what they want in new citizens. They're under no obligation to make you a citizen, to naturalize you. We're going to uphold the legislation. By this time, Holmes is pretty cantankerous. He is over 90 years old. It is said that from time to time he would fall asleep on the bench while they were arguing before the Supreme Court. Time to time he would rouse himself and immediately know exactly what question to ask, and then fall asleep before the answer was offered by the lawyer. He didn't have a whole lot of respect for this woman's views, but he had a whole lot of respect for her intellect, for her knowledge. And he was just a little unhappy about the government's position here. He was speaking as a man who fought in the Civil War. In the Civil War, and now as a 90-plus-year-old man, he's hearing this case of this conscientious objector from Hungary, who in the late 40s of her life, she doesn't want to agree to fight in a war for the country she wants to become a citizen of. He separates this argument from Schenck, and he supports what she's doing, even though he really doesn't like what she's actually saying. Her position and motives are wholly different from those of Schenck. She is an optimist and states in strong, and I do not doubt, sincere words, her belief that war will disappear and that the impending destiny of mankind is to unite in peaceful leagues. And this is Holmes, who fought in the Civil War. I do not share that optimism, nor do I think that a philosophic view of the world would regard war as absurd. But most people who have known it regard it with horror, as a last resort, and even if it not ready for cosmopolitan efforts, would welcome any practicable combinations that would increase the power on the side of peace. Holmes then says, some of her answers might excite popular prejudice, but if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. Freedom for the thought that we hate. That is the essence of what Holmes was counseling in the Schwimmer case. And it is a wonderful phrase to capture how this man had journeyed from the 1907 case in Patterson versus Colorado. He knew the government wasn't going to ask her to fight for them. He knew that she was taking a philosophical position to make a point. He didn't like her argument that war would stop. He didn't support her unwillingness to be part of that war, but he supported her right to advocate that view. It wasn't going to harm the government. And so free speech for him had become an absolutist, total protection for freedom of thought, just like the argument by Robert Jackson in West Virginia versus Barnett, just like the argument by William O. Douglas in Murdoch versus Pennsylvania, just like the argument by Anthony Kennedy in the Alvarez case. Some of her answers might excite popular prejudice, but if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. Protecting the freedom of thought that we hate. I can't imagine a better phrase to articulate what the framers meant and what the people understood, having fought for the ability to say things against the crown and parliament in the Revolutionary War, what they thought they were designing in American democracy. This is the American democracy that they wanted to achieve.